Hi everyone, this is Ifeoma Odunlami, immigration attorney from the Odunlami law firm. How are you all today? Um, all right, so um, I wanted to talk about, I had told you guys last week that I had a couple of really great successes. My firm, we got some really great successes, and I talked about one of them last week. One of them was the case of our client that who was minutes from being deported. I mean, he was literally on on the plane. Like they had taken them to the plane, everybody got out, and he was taken off the line because we were able to win a stay of the deportation proceedings. We were able to terminate. We filed a motion that and it was we won that. So our client gets to stay back with his family, his wife, his children, and so that was really great. And so that same day, I also had interviews, I-751 interviews, and that's what I want to talk about today. I-751 interviews, guys. I-751 interviews are no joke, and I will explain why. So for those who are just joining me, thank you for joining. Please post a comment on the comment section telling me where you're joining from. I always want to know where people are joining us from. We are here in New Jersey, and we represent clients in all 50 states and abroad. And we've been trying to hook up a system with WhatsApp so that our clients abroad can reach us more easily. So once we're able to do that, I will let you know. But for now, the best way to reach us is 973-993-1900. And so let's talk about the I-751 and the I-751 interview. So how do you get to the stage where you have to apply for the I-751? It's when you are removing the conditions from your temporary green card. So for those who do not know this, hi guys, thank you for joining me. Let me tell you how this works. So you get married to a US citizen or a green card holder, and your marriage is less than 2 years at the time your green card is approved. What you get is a temporary green card. Now, for you to get a permanent green card, a 10-year green card, you have to remove the conditions on those on the green card, and you have to remove the conditions within 90 days of the expiration of your 2-year green card. And so to do that, you have to file the form I-751. The filing fee for that is $680. And you're supposed to file it with your spouse, and both of you, remove the conditions. You show that your marriage is still, it's viable, you're doing good. And even if your marriage is, even if your marriage is, you're not together with your spouse, if your spouse agrees to remove the conditions with you, you can tell the USCIS officer that, it didn't work out, but it was a great marriage. It was a real marriage. It didn't work out for whatever reasons. And you can still get your green card. But a lot of times when marriages are failing or have failed, there's a lot of animosity, right? So there are 4 waivers that allow you to remove the conditions on your green card by yourself without the help of your spouse. So the first waiver is the waiver of divorce. If your relationship, your marriage has ended and you get a divorce, you can file the I-751 and apply to remove the conditions on your own. And I need to here mention that a lot of people are afraid of getting divorced from their U.S. citizen spouse or green card holder spouse because they think that means that they cannot get their permanent green card. And so I have people who come to my office who say, my spouse is threatening to get a divorce and I don't know what I'm going to do. How am I going to get my permanent green card? Listen, let them get a divorce because you can use the divorce waiver. And if you're using the divorce waiver, all you need to show is that all you need to show is that it was a bona fide marriage. It was a real marriage at the time you guys got into the relationship. You married for the right reasons, good faith marriage. You didn't marry just to get a green card. and and the marriage didn't work out. So when you're showing that it's a bona fide marriage, you want to show that you want to submit evidence. This is key. You can't just send the I-751 and the filing fee. They will deny it, right? You want to send evidence to show that it was a good marriage, similar to the evidence you presented when you got your green card. But at this stage, you want to show more evidence up from when you got the green card to whenever the marriage stops, being viable. And in my office, we typically just put everything, what you had before you got the green card continuously to when the relationship stopped working. So that's the divorce waiver. So if you know somebody who is afraid that their spouse is going to divorce them, or who's been threatened by their spouse that they're going to divorce them, and that person thinks that that will stop them from getting their 10-year green card, now you know better. Now you can tell them you can still get your permanent green card without your spouse. And you can forward this video to them so that they can hear it for themselves. Now, another waiver is the waiver of extreme physical abuse or extreme cruelty. This is similar to VAWA. And this is the waivers that I used for the interviews I attended recently that we were successful, and they were hard interviews. Let me tell you, the I-751 interviews are hard interviews because you've gotten the temporary green card, and USCIS gets a chance to review your application again, so that if they miss something the first time, they get to review it again and ask questions again. So don't think that because you got a temporary green card that you're guaranteed to get your 10-year green card. I get people that call here and say, well, I got my temporary green card, so it's not a big deal. It is a big deal. And the big deal is that typically when you get your temporary green card, you might not have as much evidence as because you're newly married, and sometimes they allow that because they understand that there's a lot of financial commingling you may not be able to show at that point because you've been you're newly married and all that. But by the time you're removing your conditions, you have to come correct with evidence showing that it's a bona fide marriage. So if you're using the waiver of abuse, you still have to show that it was a real marriage, and then you have to show that there was abuse in the relationship. So if you use the waiver of abuse, you don't have to be divorced from that person. You don't even have to be living separately from that person, because sometimes part of the abuse is you having to stay in that abusive situation because there's just no way out. So one of the cases I went to, my client was still in that marital relationship. My client had not gotten a divorce yet. So we were able to show that there was abuse in the relationship, right? And it didn't matter that he was still living with her. It didn't matter that they were not divorced, So you need to know that there's no requirement that you're not living together. Now, the physical abuse or extreme cruelty, that's a tough one when you go on an interview for that, because a lot of clients find it hard to revisit that trauma, and they find it hard to discuss it. So we prepare our petition, just like a VAWA, Violence Against Women's Act, we've talked about that. Similar to that, but the difference between this and VAWA is that there's no interview with a VAWA application. And with the VAWA application, you don't have a green card. So with the I-751, you already have a green card. You're now trying to remove the conditions on the green card. And so the officers will ask a lot of questions. And sometimes it's really, really hard, really, really traumatic. I've seen it for myself, really, really traumatic for people who are in these abusive situations to be asked questions about it. But they have to ask them this question. So that's why I think it's so much more difficult than a VAWA petition. What are the types of abuse that you may suffer, right? It's like VAWA, it could be physical abuse, but it's not necessary for it to be physical abuse. It doesn't have to be physical abuse. You don't have to show a police report. You don't have to show pictures of injury. You don't have to show hospital reports, because it can also be emotional abuse. It can also be financial abuse. It can also be verbal abuse, psychological abuse, sexual abuse. And there's just so many horrible things that can go wrong in a relationship, where somebody who doesn't have the power in that relationship feels like they're being controlled, they're being minimized in front of people, embarrassed. Um, in fact, one of the cases I went on, my client's spouse actually reached out to USCIS and asked them not to approve his I-751, because apparently they had filed it jointly together. They had filed it together, and then the relationship broke up, and she wasn't going to be a part of it anymore. And so we had to go on a waiver, and but she still had the presence of mind. This is how abusive this person was. She wanted to make sure he didn't get a green card, so she wrote into USCIS asking that the green card be denied. But as you see, we won it, and I'm happy for my client. But we didn't even know for a fact until we went for the interview. And so that could be part of the abuse, just trying to control this person's future, because there was also the threat of deportation, threat of contacting ICE, threat of not showing up for the interview. If you or somebody are being threatened in this way, that you can get your green card. You're not helpless. The law does not make you helpless. The law is on your side. As long as it's a bona fide marriage and you're being abused, you can strike out on your own and get your green card, whether your spouse, your U.S. citizen spouse or green card holder spouse, approves of it or not. They have no power in this situation. Even if they call ICE, even if they call USCIS, even if they tell USCIS not to grant your petition, they have no power. So I want this information to empower you so that you can go for what you deserve. So now I'm going to come back to the extreme cruelty because I wanted to chit chat on it a little bit, but I want to go over the other exceptions, and then I'll answer some questions, the other waivers. So death is a waiver if your U.S. citizen spouse or green card holder spouse passes away. You can still remove your conditions by showing the death certificate, and also you still have to show that the marriage was a genuine marriage and it was entered into for the intention of living together until this very unfortunate incident of the spouse dying. Then the fourth waiver is the extreme hardship. So the extreme hardship is really the petitioner showing that they would suffer extreme hardship if they had to leave the United States, right? And it could be because there's something going on in their country, like if they're from maybe Ukraine where there's war, or there's something happening here in the United States to a family member where they can leave. There are many ways to show extreme hardship, and this is actually the only waiver that you don't have to show a bona fide relationship necessarily. So going back to the interviews I had, right? One of them had filed a divorce, right? But we still actually were, we could still go on either the divorce waiver or the extreme, the abuse waiver. And I'll tell you what the difference is. If you get your conditions removed based on the abuse waiver, you get to file for your naturalization within 3 years of you getting your green card the first time, right? So a lot of times, by the time you get to the interview, it's already 3.5, 4 years, which means that you can actually naturalize you can file to naturalize at the same time. Or you could even have filed to naturalize once the 3-year mark was reached, right? If you were confident that you would prevail on the extreme cruelty or physical abuse waiver. Now, with a divorce waiver, you have to wait 5 years. 5 years from when you got your green card. And so, that's just, the difference there. So let me answer a couple of questions because I have to go soon. I'm going to start with Facebook. Macan Triore says, can I refile a PD request here? Let me put this on. Can I refile a PD request while my motion to reopen is pending and the previous PD request was no response by ICE? I have no criminal activity. So, Macan, you can always refile, a PD request. But I hope you have an attorney helping you with this because, just because you have no criminal activity does not mean that your PD request will be granted. Remember, it's prosecutorial discretion. It's a discretionary relief, So I hope you have an attorney that can show you, that can put your case forward. But there's nothing in the rules that say that you can't file another PD request. But I hope you have something additional to add. All right. Let's see. Amarjeet says, I'm in California. My I-360 was approved. I applied for I-485 in February 2023 and got fingerprints done in March 2023. Case has been Nebraska. So when will my I-475 be approved? Amarjeet, if I knew that, I tell you, if I knew that, or any lawyer knew that, we would be so relieved because immigration, case status, processing times are so all over the place. But I can tell you that sometimes, in my experience, we've had most of the times our clients have gotten their green card within 6 months. But it really depends, it depends on where your case is, and I really can't answer that without knowing where your case is because there some offices are more backed up than others. But congratulations on having your I-360 approved. And as long as you don't have any inadmissibility issues, you shouldn't have any worries for your I-485, okay? All right, so let me go through, let me check Instagram, and then I will sign off until the next time. I'm looking for, I don't see any questions right on Instagram. So let me go back to Facebook. F Baby says, good morning, great attorney. Hi, F Baby, how are you? So F Baby says, I'm an asylum seeker. I got my work authorization in May, a social security card. When will I get an interview with USCIS to grant me asylum? Because my case is with USCIS, not court. So F Baby, you filed an affirmative asylum case. And same question, same answer to Amarjeet. I don't know. Asylum cases are taking a long time. But what you can do is you can go to the case processing website and take a look, put in the information, and it will give you the average time that you have to wait for your case to get to an interview stage. But honestly, it's taking a long time. And I'm glad that you got your work permit and you got your social security card. So at least you can work and not have to worry about being able to take care of yourself while you're waiting for your asylum case to be processed. All right. So the Portia says, so if you have I-360 approved with a waiver, well, I-360 is VAWA. That's different. Well, I-360 is VAWA. It's also a whole, there's other relief types that you use it from I-360. I-360 does not have a waiver. I-751 is the removal of the conditions. It just happens that you can use the abuse waiver just like VAWA, but I-360 is different from I-751. So I-360 doesn't have the type of waiver you're talking about, right? Which is, getting your green card, when you have to self-petition. So it's different, Portia. I hope you understand what I'm trying to say. So Portia also says, from fees, when you file the I-485, will the same apply, or do you have to reapply? I'm not really sure I understand the question, so I'm going to take a stab at what you're trying to say. So the I-751, you're not doing an I-485. You're not adjusting status. You already have a green card. It's just a temporary green card. So with the I-360, If you file the I-360 together with an I-485, then you pay the fees for the I-485 because the I-360 does not have any filing fees. Now, if you have to file a waiver for an inadmissibility with the I-360, that's different. So you have to pay for the waiver if you are inadmissible when you have to file a VAWA. And you could be inadmissible because you have a criminal background or there was misrepresentation or fraud sometime at some point. Then you file a waiver, but that waiver is a waiver of inadmissibility. That's different from the I-751 waivers. Okay, all right. Right. I hope I answered your question, Portia, because I think you're conflating the I-360 and I-751. They're two separate petition types. All right. So if you're going to file the fees with the I-360 and you're going to file an I-485, the fees are $1,225 for the I-485. Now, there's a time when if you file a VAWA petition and you have a previous I-485 pending with another relief type, you can actually move that I-485 to your VAWA, right? So I don't know. I hope I haven't confused you more, but yeah. All right, guys. Let's see. I think that's pretty much it. All right, guys. I'm gonna head out, but thank you for joining me today. And my office is closed July 4th. And my office is closed July 4th, and I wish you guys happy July 4th. So I'm going to take one more question. Amajit says, my I-485 is Nebraska, and it's for an abandoned child. Okay, so it's a special immigrant juvenile status. So that's another thing. You can use the I-360 for special immigrant juvenile status. So same thing, for special immigrant juvenile status, let me go back to the first question you asked me at Marjit. Now, for special immigrant juvenile status, the priority dates have retrogressed, which means that depending on when you file the application, you might have to wait a while. The child may have to wait a while before the I-485 the priority date is reached. So basically, with the I-360 SJIS, if you file an I-485, they're working on cases from, I think, September 2018. So what that means is that you have to wait until the date of your filing to become current before you file the I-485. So if your priority date was before September 2018, then you can go ahead and file your I-485. All right. So that'll be all for now, guys. Take care and have a great weekend.